Oh, you were having a great time today, folks. Technical difficulties aside, it's great to have you back. My name is Matthew Leffler. I am the armchair attorney, and I am here today to talk to you about all of the wonderful things happening in this incredible supply chain. There's the music. I'm a real life lawyer. I don't just play one on television. I will always say don't take legal advice from a podcast or a streaming service. If you think you need a lawyer, you probably do. It's not me, unless of course you're paying me. Then I maybe I am your lawyer, but I don't think you are. I think you're just listening or watching. And today's broadcast is brought to you by our great friends over at DAT Dial a Truck. Since 1978. 1978, DAT has been helping people move freight across this country. There was a time when there was no internet. There was a time when there were no ELDs. But freight doesn't stop. Freight doesn't even slow. It just continues on and on and on. So thank you for DAT for sponsoring this podcast for over a year, maybe a year and a half, maybe even 2 years. One of the best teams in freight. I am so grateful for their support as we continue to experiment in this wonderful world of creativity. Now, we also have to thank our newest sponsor, our friends at Genlogs. Right there. There it is. Haha. Hovering a little bit near me. Genlogs is a technology, hardware, software company combating one of the biggest problems facing our industry: cargo theft and fraud. Who are you working with? Maybe the cameras know. The camera knows all. I love Genlogs because they share a vision that I have. And the vision that I have is to leverage technology and use that to go right to the cusp of what you are allowed to do legally to combat these incredible blight we have in our industry of cargo theft. That's over $35 billion. That's billion with a B. It's a lot. Now, today's broadcast, we're going to just jump into what we're talking about. First and foremost, breaking news. Breaking news. Yes, I assume I'm breaking some news. Maybe I am. Let's see. Truck Parking Club. There it is. Look at that. Evan Shelley. Reed Lose-A-Lot. Lose-It. Lose-It. How do you say that? I think that sounds right. Great news out of FreightWaves. We're reading some news today. Truck Parking Club has accepted a strategic investment from Cat Scale, North America's largest truck weighing network, making parking more accessible for truckers nationwide. I don't have to tell you that parking commercial vehicles is a problem, but if it maybe I do. Actually, let me back up. Maybe I should tell you. Parking commercial vehicles in this country is a problem. For every one spot available, there's up to 11 trucks on the road. Now, if you care about safely delivering freight on time and undamaged, as I certainly do, then this is encouraging news. What we see in Truck Parking Club is the idea of finding a way to take property that wasn't available for parking and making that available for parking, opening up more parking capacity. I love the team at Truck Parking Club. I've been following them for a minute, and it's great to see someone as well regarded as Cat Scale putting some strategic capital behind that great American business. That's pretty cool news. I have to admit, it's pretty exciting. Now, I'm going to dive into a couple of things that I've been meaning to get to here. I haven't had a chance to really dive into them, and that is not an interview. Not an interview. It's talking about some legal things happening in our industry right now. And the hope is that I'm able to help you understand some of the nuances of what's taking place. So we're going to start with an article that I published just recently with the Journal of Commerce. I'll hyperlink that article for you in the show notes. But I'm going to kind of walk you back to the days when this case kind of started to capture the imagination of our country. It's a tragic, absolutely tragic set of facts. And I don't take any pleasure like regaling you with the visceral details of this, but the story goes that a truck driver for Werner Enterprises is operating his truck and he's driving beneath the posted speed limit because it's snowing. It is a snowy day. And in another lane, the opposite side of the highway, is another driver. And that driver is operating a pickup truck. And they have some kids in the car, among other things. And that vehicle, that pickup truck, is going too fast for conditions. They're going too fast for conditions. And how do we know they're going too fast for conditions? Well, that passenger vehicle, that pickup truck loses control. They spin out and they cross a 42-foot median. And within seconds of losing control, that pickup truck has a head on collision with that truck operated by Werner Enterprises. One child dies, another child is catastrophically injured. And the question becomes, who is at fault? What do you do? And I've talked about this case quite a bit. I've talked about it to my law school class. I've talked about it at conferences all across the country. And I continue to follow it because it is something that is truly remarkable. It's something that is important to understand who's at fault when something so catastrophic takes place. And here's what happens. It goes to trial. It goes to trial. And the plaintiffs, the people who are representing the injured people, they make the argument that Werner didn't train this driver enough. This was a new driver, had only been driving for a week or so. The driver had a trainer, and the trainer was asleep in the back of the truck, asleep in the berth. And that's how we typically run trainer-trainee relationships in transportation. So for you, those of you who are not familiar with this industry in depth, it's normal, generally speaking, for the trainer and the trainee to operate like a team where one is working and one is resting. And they have this whole schedule of when you're working and when you're not working, doing your duty or you're not on duty. Any event, the driver also didn't have some specific training around driving in snow and ice. And I'll also just kind of mention for those, again, who don't know this, there's no legal requirement to learn how to drive in snow and ice in the United States. Like that's not part of the CDL requirements. It's good if you are trained to drive in snow and ice, but doesn't mean you have to be. Well, suffice it to say, this ends up being the argument advanced by the plaintiffs. You were driving too fast, you didn't have enough training, and therefore you ought to be held responsible. Werner, on their part of the argument, is we were operating the truck safely. The maintenance was fine on the truck and the trailer. We were under the posted speed limit. We never left our lane, and we never lost control. We should not be held responsible for this horrifying set of facts when someone has passed away. Tragic though these facts are, it doesn't mean that we have to be the ones held responsible. And unfortunately for Werner, at the jury trial, that was not what was believed. The jury returned a verdict against Werner Enterprises. They established liability. They said the driver for the pickup truck had 16% fault, 16% fault. The liability for the truck driver for Werner, the driver of that tractor trailer, had 14% at fault. So now we're up to, I'm a lawyer, not a mathematician, but we're about 30% to our number of 100. So they turned around and said that 70% remainder, that is Werner's responsibility. So taken together, the driver for Werner and Werner itself was held to about 84% liability. Now, the way that law works in many jurisdictions is a thing called joint and several liability. That means that if you're liable for part of it, you're liable for all of it. And what was all of it? About $100 million. Now, this case happened in 2014. It has been litigated for over a decade. Now, it went to the appellate court. So when you lose at the trial level, whether you're the plaintiff or the defendant, you have the right to appeal it and say, hey, I think the lower court got it wrong. I think we should look at this set of facts and look at this law and reevaluate it. So it did get appealed. And on appeal, it was looked at, and the appellate court, the intermediary court for Texas, came back and said the trial court got it right. They didn't err. Werner must be held responsible for this entire amount. That number was initially $100 million, but it got increased because of a thing called post-judgment interest. So when you're at trial, when you lose at trial, there's this number you have to pay. And until you pay it, the interest continues to accrue, and it can get very expensive. So that $100 million is now closer to $130 million. Well, what do you do? Well, what you do next is you appeal to the Supreme Court of the state that you're in front of. So you go from the lower court to the appellate court to the state Supreme Court. And in December of 2024, about 6 months ago, 7 months ago, it was argued before the Texas Supreme Court. And the arguments were the same ones that I talked to you just about a moment ago. And those arguments were we never lost control. We had a well-maintained truck and trailer. We were under the posted speed limit, and it was utterly unforeseeable. We could never have foreseen that someone else would cross a center line, cross 42 feet of median and smash into us. That's unforeseeable. Just because we were there, it doesn't mean we're at fault. And when I first listened and watched the oral arguments, I felt, based on the questioning of the various judges, that they might reverse. I thought this sounded like they might reverse. And it's not just the oral argument that you have to think about when it comes to appeals. Other people have opinions, and those other people file their opinions in a thing called an amicus. It's a friend of the court. You file another piece of paperwork saying, hey, I really care about this case. I'm not a party to the case, but I have some thoughts I'd like to share. And it's interesting who also shared thoughts on this case. I believe the American Trucking Association filed an amicus. I believe Schneider, one of Werner's largest competitors, filed an amicus. And it just goes to show that the industry was very, very interested in the outcome of this case. Well, the news broke about a week ago, maybe 2 weeks ago, that the Supreme Court of Texas reversed the lower court, reversed the appellate court, and said Werner is not liable. Werner cannot be held responsible for the negligence of the other motor vehicle. Now, maybe Werner made mistakes during the process, but those mistakes, the training, the speed, they did not cause the accident. Negligence is like a math equation, and anything in law is kind of like math, but with words. So when you're trying to prove negligence, you have a duty to do something. You have to show there's some sort of causation, a breach of the duty, and then there's causation, and then there's damages. And if you can defeat any piece of that pie, then you can stop the claim. And the thing that we fought about was causation. Did Werner cause this crash? And ultimately, the Supreme Court of Texas said, no, they did not cause the crash. So that gets reversed, goes back, and that's the end of it. So this is perhaps one of the most important liability verdicts in the trucking industry's favor that we have seen in a very long time. For a very, very long time, the trucking industry has been looked at as a giant piggy bank. You have a giant trailer, and behind that giant trailer is unlimited amounts of money. And if you're careless, if you're not paying attention, and you end up smashing into a truck or trailer, you may just win the lottery in some form or fashion. I don't mean to be pejorative, because I don't like these types of cases. These things are horrifying. I mean, I'm telling you, as a former civil defense attorney for trucking companies dealing with catastrophic injuries, nobody wants to read the medical records and see the horrible injuries and suffering that someone takes when they have something like this happen. But you have to be able to set the emotion aside. Oh my gosh, it's horrifying to see a kid not make it from a crash or to be paralyzed. It's horrifying. There is no person that I've ever met that has been excited for something like that. But when you go to trial, you never know what the jury's going to do. It is a roll of the dice in so many cases. In this case, the dice rolled against Werner initially, But as time went on and the appellate process was exhausted before the Supreme Court of Texas, that case is reversed. That vert is gone. Now, what does that mean for people going forward? My goodness, that's a really good question. I don't suspect you're going to save money on your premiums anytime soon. Maybe you'll see modest increases, but more than anything, the goal for us as the trucking industry is to make sure that we are very clear about what actual causation is. And just because we're there does not mean that we're at fault. So huge victory for Werner. Big, big congratulations to that team. And it just, again, goes to show it is dangerous doing this job. I mean, even when you are out there trying to safely deliver freight on time and undamaged, it is still a challenge. I say this often. Driving a truck is the 8th most dangerous job in the world, in the United States at least. 8th most dangerous job in the United States. And yet it's the most common job for so many Americans. Millions of women and men get in those trucks and they get the things that you need in your house or on your shelf or at your door every single day. 70% or more of everything that you want, love, and need comes on a truck, through a truck. So that case, that Supreme Court case in the Werner example, that's done. It's over. There's no additional appeals. In some contexts, sometimes you can appeal from the state Supreme Court to the U.S. federal Supreme Court. And that's not the case here. That is not a federal issue. So that is done. That is toast. Now, the other case that we're going to talk about, and it's actually 2 cases, actually maybe more than that, is this idea on broker liability. Now, I will be talking about broker liability with my good friend Charles Gracie here in a little bit on Sirius XM Radio on the Legally Loaded segment. But I want to give you guys a taste of things to come, because if I'm going to be talking about cutting edge law, you probably should know about cutting edge law. That's what we're here to do. So here's the idea. The idea is generally this. There are these entities called shippers. That's the manufacturers, retailers, the people who who need things moved. And then you have these intermediaries. Now, the intermediaries are often freight brokers or 3PLs. There's other ways you call them, 4PLs, managed transportation service providers, all sorts of names. We usually call them freight brokers. And so freight brokers work with a shipper and they figure out how much the shipper is going to pay the broker. And then the broker tries to find capacity, try to hire a trucking company. And they hire the trucking company to perform the movement of that particular load for the price that the broker and the motor carrier agreed to. So I'm not going to go down the path of broker transparency, though it's interesting to think about like this is all tied together. But broker liability kind of stands for this premise. If you're a broker of freight, you are in charge of price, route, and service. That is what you do. You are not a guarantor of the safety of the motor carrier. You're not the motor carrier. You are an intermediary. Your liability extends to what is inside the box. I mean, that is what you're doing. You are not a hiring entity for a trucking company. But what we have seen happen and what has become so interesting over the last couple of years is this split. And I use the word split intentionally because what we have is this really strange phenomenon of federal appellate courts looking at cases not that different from Werner and saying maybe the broker should have made a different decision. So let's take the example we used with Werner just a moment ago. And let's just say that it's not Werner, it's just some other random trucking company. Random trucking company, the truck driver falls asleep and smashes into somebody. Something catastrophic happens. The question becomes, who's at fault for the trucking company and the guy who falls asleep and smashes people? Well, clearly the driver and the motor carrier are responsible, but increasingly, plaintiff attorneys have looked at the broker and said, you should be at fault. You're the one who picked that person. And if you hadn't picked that person or that entity, that company, I wouldn't be in this position now. It's not that different from what we talked about with Werner. If Werner just didn't have a truck in that one spot at that one time, and that pickup truck spun out, crossed the 42-foot median, and What would they crash into? Nothing, maybe, because there's no Werner truck there. This is the argument that gets advanced by plaintiff attorneys against brokers. Now, the transportation industry is about $1 trillion a year. It is very, very big. Now, the amount that brokers are involved with is about 20%, maybe more, maybe less. I'm not a Ken Adamo or a Jason Miller type. They might know this far better than I do. But what I do know is brokers are moving more and more freight every single year in comparison to the pure asset base directly working with a shipper. So it stands to reason that more brokers are going to get sued, and more brokers are being sued. And as brokers are sued all across this country, when something catastrophic happens, there is this thing that brokers get to use, and it's called F4A preemption. And F4A preemption is just a simple way of saying, hey, Congress made a law, and in that law, they said we can't be held liable for what the motor carrier does. That's what Congress said for us to do. But there was this little exemption inside of the F4A statute that said if it's a safety regulation, then you can hold someone responsible for it. And that piece, that kind of safety regulation, that's what we've been getting all tied up around, all spun up around. And what has now happened is that different federal courts sitting all across the US have read the statute and come to different conclusions. That is not that rare, just so you all know, when lawyers can look at the exact same set of words and say they mean the exact opposite. Now, for a long time, we just had two circuits that were disagreeing on what the words meant. There was the Ninth Circuit Court of Appeals, that's like California and Washington and Oregon, and they said, when they looked at it, that yes, in fact, the broker can be held responsible if the motor carrier makes a mistake. And they say, well, broker, you should have known. You should have known this trucking company was unsafe. You hired them and they went off and did something terrible. And the brokers would say, this is a motor carrier that has been authorized by the federal government to move freight. I can't anticipate they're going to have a crash. That's not what I'm here to do. My job is just to link up people and be an intermediary for the transportation. Not a guarantor of the safety of this motor carrier. That's on them. Now, we had another case come out, and that was in the Seventh Circuit Court of Appeals. That's Global Trans versus Yee. The one I just mentioned was C.H. Robinson versus Miller. In the Seventh Circuit case, same basic set of facts. Global Trans, the freight broker, hires a motor carrier. Motor carrier has a catastrophic accident. Everybody gets sued. Everybody gets sued. Let me be very clear. Everybody gets sued. Now, as it goes through the process, Global Trans advances the argument that they are preempted. You can't sue me for this because you're not allowed to. The federal statute says I'm not someone you can target. And the Seventh Circuit agrees. The Seventh Circuit Court of Appeals agrees. Now, both the Miller case in the Ninth Circuit and the Global Trans case in the Seventh Circuit get appealed. They are asking the U.S. Supreme Court to listen to them. Now, the United States Supreme Court is fascinating. It is fascinating. Like, really cool. Lifetime appointments, ethical rules that are kind of like they get to make their own kind of rules. What they take up is whatever they feel like. There's only a very few, very, very few types of cases that the Supreme Court must hear. So it's a court of discretionary appeals. So they get the appeals and they just say, no, we don't. C.H. Robinson versus Miller in California and Ninth Circuit, don't care. Global Trans versus Yee, Seventh Circuit, don't care. Things are changing. Things are changing. The 11th Circuit had another case. This was a case of the Landstar case. And in the 11th Circuit, they agreed with the 7th Circuit. This was a cargo theft one, but the same kind of general idea gets at play. Can the broker be held responsible for something bad happening on the part of the motor carrier? And the 11th Circuit kind of agree with the 7th. So now you're starting to see the cracks. The cracks are where you see the federal circuits coming up with different ideas. Now, what has been so fascinating is in the last, let's say, 2 weeks, a lot of interesting things have happened. And this is what I will be talking about. And you'll hear a lot. You are all going to hear a lot about this over the next couple of months. I have no doubt about that. But in a nutshell, what has happened is that the Seventh Circuit, in a case called Montgomery versus C.H. Robinson, same idea as this. Someone is in a trucking company, injures somebody, and they sue the broker, and the broker says, I'm not responsible. Even in these jurisdictions where it's been like decided, like, hey, I get it. We're not liable in this jurisdiction. People still sue the broker. They still sue you. They still sue the broker because for them and how they see it is until the Supreme Court weighs in, it's still a good argument. Maybe it gets knocked out, but I'm still going to make it. I'm still going to make every argument I can because it's not definitive. So C.H. Robinson wins this case, and the plaintiff who lost appeals to the U.S. Supreme Court. And they file their brief and they say to the Supreme Court, please take this case up. We think that the Seventh Circuit's wrong. We think you should listen to the Ninth Circuit. And we sit there. But what Robinson does, and I deeply admire this. They respond. They file their own brief to the Supreme Court. And instead of saying, Supreme Court, we just won, don't take this case. We won, don't take it. That's what Global Trans did in the Yee case. When Global Trans won earlier, Global Trans told the Supreme Court when Yee appealed, don't take it. We won. Don't take it. There's no reason to take this case. C.H. Robinson does the opposite. They say, take this case. We need clarity. We are a big player in this space, but even if it's not all about us, the rest of our industry, we need clarity. That is impressive. That is awesome. That brief was just filed a couple weeks ago, and you should. I'll try to link it in this broadcasty thing. You'll see in the podcast, like, hey, here's the hyperlink for C.H. Robinson. So we sit at that, and that's interesting. But we also had something new happen. What has happened in the last week or so is the Sixth Circuit Court of Appeals, which I believe is like Michigan, Ohio, maybe Tennessee. They had a broker liability case. And in that case, we're back at the same question we were all asking when we first began this segment. Can a broker be held liable for alleged negligent hiring of a motor carrier? And they came to the same answer as the Ninth Circuit. That is wild. Now, that crack that we were talking about is about that wide. We are talking about a much bigger crack among the circuits. Now you have on one side the Ninth and the Sixth. On the other side is the Seventh and the 7th and the 11th. That's it. This is the time for the Supreme Court to take a case of broker liability up. What I would recommend, and I'll tell you, like I love what I do. I love being able to talk about these things to the audience that I have. I never know if people are listening. I know a lot do, and some people find this useful and they listen to the podcast or the clips we make. I believe the Supreme Court will take up the Montgomery versus C.H. Robinson case, and I believe they will take up this new Sixth Circuit case, and they will combine them, and they will have a joint case on both of these issues, and they will come to determination. And their determination, if I'm reading the tea leaves, is that they will ultimately agree with the Seventh Circuit, which I believe is the correct interpretation. I believe the Seventh Circuit is right. Brokers should not be held liable for the negligence of a motor carrier. It's absurd to think that they can be, but I understand why. Because if you're sitting in a jury and you're looking at a case where something horrible has happened, like the case we just mentioned about Werner, where Again, Werner's driver did nothing that caused that accident. And yet a little kid and another little kid and another little kid, 3 kids were injured in that case. 1 kid died, 2 were really injured. And you look at a sympathetic jury and you say, they're the ones that are at fault for this because they're the ones that were there. They're the ones, it just so happens, that have the money. You cannot let emotion blind you. That is why law is the way that law is. If you argue the facts, if facts are on your side, you argue the facts. If law is on your side, you argue the law. But as we sit here today, as we look at this case unfolding before us, it is time for the Supreme Court of the United States to take up a case on broker liability. And they have the perfect case in front of them now, which is Montgomery versus C.H. Robinson. And we have the Sixth Circuit case that just came out as well. That I don't believe has been appealed to the Supreme Court yet, but absolutely it will be. And if we value the transportation industry, which again delivers 70% of everything that you own, then we have to have SCOTUS give us clarity. And if you are of the opinion that brokers should be responsible for negligently hiring a bad motor carrier who then goes off and commits some horrifying act that causes a bunch of damages, we need to change the law. F4A is very explicit, as far as I can tell, that it does not allow you to sue the motor carrier, to sue the broker from the motor carrier's behavior. I think it's clear as day. Now, I understand why the Ninth Circuit did what they did. I understand why the Sixth Circuit did what they did, but they were both wrong. The Seventh Circuit is correct. The 11th Circuit is correct. And when it goes to the Supreme Court, and God willing it does, the Supreme Court will come out to the exact same conclusion that the Seventh Circuit did and say the clear language of this statute is to create a deregulated industry with uniform laws and enforcement mechanisms. If we as a country or we as a nation decide we don't want it to be that way, we must amend what the law says. If we don't want to amend what the law says, then we have to live by what the law explicitly tells us. The Supreme Court has punted now twice on broker liability. Once with C.H. Robinson versus Miller in the Ninth Circuit, and again with the Global Trans v. Yee case in the Seventh Circuit. That was years ago, and as they've waited, the law has been percolating. And I will say, I've always wanted to talk about percolating because that's exactly the language that the Supreme Court uses. They want these things to percolate. If only one circuit does one thing and the rest do a totally other thing, then chances are that one outlier will eventually capitulate and do the same thing. So I know a ton of lawyers in this industry right now who are aghast by the Sixth Circuit ruling, the Sixth Circuit saying brokers can be held liable. I'm excited because we were not going to get a shot at the Supreme Court without more of a circuit split. We now have 4 circuits that have weighed on this issue, and they are split, which means if you're a broker and you're moving freight anywhere in the U.S. and there's an accident, there are at least 2 jurisdictions where you can be held liable. And what that liability looks like, just look back at our conversation earlier about Werner Enterprises. When a truck and trailer and driver did not cause an accident, they were simply driving in their lane under the posted speed limit in inclement weather, and another vehicle loses control, crosses 42-foot median, and hits them head on, and they were found liable for $100 million. Now, Werner is a big boy. They have the capacity to litigate these things. If you're a broker and you get tagged with a lawsuit like that, or God forbid, a judgment like that, you're done. There's a handful of companies that can survive this. What we need, and what I am excited and hopefully correct about, is that the Supreme Court will look at what we see in front of us. The 7th Circuit and the 11th Circuit versus the 6th and the 9th. And if we do not get them to act now, when When? I believe that in the next, the Supreme Court works in mysterious ways, but let's say 6 months. 6 months, we will have one of these cases, maybe both of them combined, before the Supreme Court of the United States. And you'll wait, let's say, some amount of time for oral arguments, and eventually, and probably a 6-3, maybe even 7-2, but probably 6-3 decision that says brokers are not liable for the negligence or negligent hiring of a motor carrier. And that would give the clarity and the uniformity that F4A was designed to do. That's what it was designed to do. So those are the cases that I wanted to cover for you all today. We'll continue to talk about them. Werner, probably not as much. There's other cases we can dig into, but this broker liability thing is fascinating. I'll probably have another article about this. You'll find, and I'll add to the show notes. Let's just pretend like I've already had it published. As you can check on that article that I just had published in the show notes, it'll talk more about this issue. But I hope this was helpful. I mean, that's what I try to do. I try to read cases and learn about them and then try to make sense of them for you. And then hopefully it becomes useful. But that's it. We'll see Jet on a future episode. We'll book in that relatively soon. It's going to happen. These things always seem to work out the way they're supposed to. Thank you for tuning in. As always, thank you to my friends and advertising sponsors. DAT, it's backwards. I always think it's the other hand. It's not. Sitting somewhat on the pallid bust of Apollo, somewhat adjacent to my chamber door, quote, the freight broker, DAT forevermore. That's a good one. I should tell Emily that one. She would probably get a kick out of it. And of course, my friends at Genlogs, setting a new standard of care for freight intelligence. Cameras, lights, maybe not lights, maybe someday, but cameras. Oh, I'm so excited for all of you. I hope you have a great rest of your day. Thank you for tuning in. I will see you all at a future date and time, of which I'm not certain yet. That is the nature of things. Thank you, everybody. It's good to see you. Hello. If people have comments, you can always ask me questions. I'll hang out for a minute. It's interesting. When I taught the class on broker transparency at Michigan State, I was like, I had to teach all the students, like, first, what is a broker? I'm like, okay, we'll start with that. What is a broker? What is a shipper? What is a motor carrier? What's all the different moving pieces? I kind of felt a little goofy trying to explain everything, but I think I did a pretty good job. This is a crazy industry. This case is very important. And I think if we get SCOTUS to weigh in, it will be an enormous victory for the industry. I would be very surprised if they went the route of the 6th Circuit or the 9th Circuit. As I mentioned, the 6th and the 9th Circuit are incorrect. They were wrong. That's okay. We all make mistakes, some more than others, and I'm certainly one of the many others. Have a great day. We'll see you later. I press the button and it all ends.